Okay, perfect. Ladies and gentlemen, we are live on Facebook and we are live on Zoom. Daniel Feruzin, president and founder of the Westside Bar Association. So excited for tonight's event. This is such a fantastic panel. I mean, it's a who's who of various areas of the law, and it's on a topic that I think is near and dear to all our hearts because it deals with ethics. And speaking of ethics, I want to go into how we get MCLE credit for this particular event. Before I do, let me please give everyone my schmeal. If you haven't joined the Westside Bar Association Facebook group by now, please bear in mind, it's free, it's on Facebook. You probably already have a Facebook account. So all you have to do is go and join. You answer like 1 or 2 questions, and that's it. We have case referrals, we have job opportunities, we have people asking questions about CCP, all sorts of good stuff going on in there. And again, completely free. If you want to be a WBA member, just join the Facebook group. If you don't want to do Facebook, hop on our website, join the email listserv, and the only emails you'll get from us are related to our events. We don't sell your email. We don't spam you with a bunch of stuff. We keep it clean. Okay, let's quickly talk about MCLE credits. The State Bar is actually ramping up how they go about moderating MCLE credits. They've even created an online system, which hopefully eventually you guys will have the opportunity to see. In order to operate within the confines of the State Bar and the regulations that they're offering, we've done a couple of things. As you guys can see, there was a registration for this event, so thank you for registering. Once the event comes to the very end, I will be providing everyone a password. Please let me repeat that. I will be providing everyone a password at the end of the event. Once the event is over, you need to email us at info@Westside Bar Association, and I'll repeat this at the end. info@Westside Bar Association, provide us the password, your full name, and your State Bar number in the email, and we will get you both the substantive written materials as well as your certificate for this event, which by the way, includes ethics credits. Okay, I'm excited. I'm gonna bow out here. Eliza, all yours.
Thank you, Dan. Good evening, everyone. I'm Eliza Ghanooni, a board member of the Westside Bar Association, and I'm your moderator tonight. I'm the principal of the Ghanooni Law Firm, a boutique law firm specializing in bankruptcy law. Thank you to everyone in the audience who has joined us tonight, and a huge thanks to our amazing panelists who are with us to discuss the unique case of the Tom Girardi involuntary bankruptcy, the related ethics and family law issues, and the ramifications of the case on the legal community as a whole. And now I will introduce our panelists. Brian Kabateck is a nationally recognized consumer attorney. Brian has netted more than $1 billion in recoveries for his clients in the areas of personal injury, insurance bad faith, pharmaceutical litigation, wrongful death, class action, mass torts, and disaster litigation. Brian is the founder and managing partner at Kabateck LLP. Demetria Graves is an esteemed family law certified specialist. She has published When Women Run the Firm, a #1 new release on Amazon, and she hosts an amazing podcast, Legally Uncensored. Demetria Graves handles all aspects of family law, including divorce, child custody, child support, modifications, paternity, visitation rights, and other related legal issues in California. Demetria is the founder and principal of the Graves Law Firm. Erin Joyce is a distinguished ethics attorney who has extensive experience in State Bar investigations and disciplinary proceedings, plus over 25 years of civil litigation experience. Erin spent over 18 years as a State Bar prosecutor. Now she defends professionals being prosecuted. Erin is the founder and principal of Erin Joyce Law. Zev Schechtman represents debtors, creditors, trustees, and other parties in bankruptcy, restructuring, and insolvency matters. And he often assists entertainment and media businesses with insolvency concerns. Zev is a partner at Danning Gill Israel Krasnov. Zev was the catalyst for this CLE. Thank you, Zev. Now we are going to play a short clip from the documentary, The Housewife and the Hustler, which highlights some of the issues we will discuss and includes a short segment of an interview with our panelist, Brian Kabateck. This video may be upsetting to some of our viewers, so viewer discretion is advised.
trust him and that he's that guy.
After a trial, or it can be just a settlement, the money goes into your trust account.
Those funds need to be held in that trust account separate and apart from the law firm.
Now, at that point in time, you're entitled to your legal fees, but the rest of the money belongs to the client. You're not allowed to touch that money. It's not your money.
To remove those funds for any reason before it's clear that there's a proper accounting of what the client should get, that is probably one of the most serious offenses by attorneys, certainly in California, and I would think nationwide.
Every single lawyer knows that if you dip into the client's account, you will be disbarred.
So he said it would take about 3 months to process getting the money from PG&E, and then asked if we'd like to keep my daughter's money and our money and then my son's big settlement in something that he'd invested in.
He suggested that he would take their millions of dollars of settlement funds and put that money into some kind of an account that would guarantee 6% interest.
And he's supposedly a millionaire. I thought he knew how to deal with money, obviously. He was, so he made it sound like it was a great thing to do. And then after everything was paid, he would send us, our balance. So we were like, okay, that sounds good. And so that's what we did.
So in the very beginning, after it settled in 2013, I mean, it didn't feel like things made sense right away.
The amounts of the investment he claimed were not accurate. He never sent any statements of any kind.
I just can't imagine being a victim and watching any episode of The Real Housewives and watching Erica Jane go through her extensive shoe collection, her closet, her home, her private plane, going on trips and flaunting all of this wealth without wondering where it came from.
Kathy and I would joke, because I was like, who are we going to call? We can't call the DA, that's Tom's friends. We can't go to the chief of police, that's Tom's friend. You can't go to the California Attorney General, that's Tom's friend. You can't go to the California Bar, that's Tom's friends. Who are we going to call? Ghostbusters? Who's going to help us?
20 or more years ago, you started hearing rumors about him not paying his co-counsel or his referring lawyers. There were stories about a lot of lawsuits that were filed against him. And of course, I think a lot of people chalk that up to big name, big cases, enemies come out of the woodwork, and maybe that's what was going on.
My name is Joe Gomez.
Thank you, Dan. Wow, that was really intense. My first question is for Brian Kabateck. What were your thoughts when you first learned of Tom Girardi's involuntary bankruptcy? And what do you think the fallout will be in the plaintiff's bar? Or has there already been a fallout?
Yeah, sure. Thank you. And I appreciate it. I'm told I might have unstable internet. So if I break up at one point, I'll be right back. Also, I host a couple of podcasts. One is called Civil Action, and the other is with my brother who's in politics in Sacramento. And we call that Kabateck. So would love to have anybody listen in on those. We do those occasionally. I think the best way for me to start talking about this is to really talk about what I'm afraid of happening here with respect to this and with what happened with Girardi. I mean, first of all, I think anyone who isn't a plaintiff's lawyer needs to understand that Girardi was the most visible plaintiff's lawyer on the West Coast, maybe west of the Mississippi in the United States. Everybody knew who he was, larger than life. So what's this going to happen? Well, first of all, I'm very concerned about our reputation, the plaintiff's reputation. And those of you that have been around long enough probably can remember back in 1992 when we had then President Bush, first Bush, who went on in his State of the Union speech and talked about tassel-toed trial lawyers. So, trial lawyers have come a long way in the last 20, 30 years to build up a reputation of trust and of doing a good job and of helping the public, protecting the public. And now we have something like this come along. So that's the first concern I have, is what is the reaction going to be to the plaintiffs' lawyers in the United States? Because believe me, I've been the president of the state trial lawyers here, the consumer attorneys of California. People, 99.9% of plaintiff lawyers are good, hardworking men and women who go to their job every day to try to protect their clients and do a good job. My second concern is client suspicion. I'm now worried about what clients are thinking of us. Are we all out for our own good to steal their money? Is that what they're thinking of? My next concern is a concern about the sort of the defense lawyers. Are they going to think we're all dirty, that there's something wrong with us? Or our vendors, the people that we generally do business with, people like that, what do they think? And the biggest concern I have is, and I know we're going to talk about this tonight on the panel, is the state bar, which in my humble opinion is an utter failure of an administrative organization in the state of California, is going to use the plaintiff's bar as the scapegoat. They're going to start looking at plaintiff lawyers, and I can see this sort of manifesting itself in several ways. First, I think they're going to be very aggressive to try to come after high-profile lawyers to show that they can go after the high-profile lawyers because they clearly failed when it came to Girardi. And I'm worried about that. So, you're going to be going after people to the point of absurdity just to try to make a statement. I'm concerned about new rules. I'm concerned about rules such as sudden, no cause audits, coming into your office and wanting to audit your trust accounts and look at things like that. Or they're trying to do things where they're going to look at mandatory sort of reporting on your trust accounts. And the public may listen to all that and go, well, that's great. Sure, we love to see that kind of thing. But again, you're really trying to patch up a problem that they had themselves with the Girardi situation. I'm worried about mandatory reporting. California doesn't have mandatory reporting. I'm sure Erin could talk about this, but in California, if you suspect another lawyer of doing something wrong, you can do something about it, but you're not obligated to. But imagine the environment that would exist if all of a sudden, anytime I thought that my co-counsel or opposing counsel on a case were up to no good, and I've got to report them, or I can get in trouble. I can be in trouble for that. And I'm really concerned about the bar now trying to make people examples, trying to get out there and find people that are examples. Look, I'm the first one to tell you there have been a slate of bad plaintiff lawyers that have gotten themselves into trouble. And we all know the stories, but it is such a small, minuscule number compared to what was going on. And I personally feel that the state bar has come and gone. Its time has passed. We need to figure out a way to dismantle them and figure a better way of dealing with this discipline problem. And I'm just afraid that we are all going to suffer. Plaintiff lawyers primarily, but every single person that's listening to this who's a lawyer is going to suffer as a result of this. So that's a long-winded answer to your question, but I think that it is something that is very, very bad for the image of the practice of law, for what we do, for what our brothers and sisters out there do. And I can't imagine a worse scenario happening with the high-profile nature.
Thank you so much for your valuable insight, Brian. That was really amazing. My next question is for Erin Joyce. On June 10th, 2021, the Board of Trustees of the State Bar of California announced, and I quote, following a review of an audit of past complaints filed against Tom Girardi, the audit revealed mistakes made in some investigations over the many decades of Mr. Girardi's career, going back some 40 years, and spanning the tenure of many chief trial counsels. In particular, the audit identified significant issues regarding the Office of Chief Trial Counsel's investigation and evaluation of high-dollar, high-volume trust accounts. Erin, what kind of mistakes do you think they are referring to, and how should those complaints have been handled?
Well, first of all, what Brian Kabateck just said about the State Bar trying to use the debacle that was or is the Girardi situation as a springboard into the mandatory client trust account audits that they've been seeking for more than a decade. That's what's coming through. They had conducted a Board of Trustees secret audit of these closed investigation files. And what they came up with is mistakes were made. Now, and from that, they've leapt to, we need mandatory random audits. And if you recall, about 10 years ago, they started doing random audits of people's MCLE compliance, which has literally no connection with public protection at all. But what it does do is it bumps up the number of cases and investigations, and they're looking for, and this is actually in the words of trial counsel, low-hanging fruit. The state bar naturally goes after the soft targets, and that is the sole practitioners, small firm attorneys, and the big wigs walk. And that actually, unfortunately, is still happening right now. That's happening right now. If you're a hard target, you're not going to be subject to bar discipline. And in this case, I'll tell you, because I was a state bar prosecutor for over 18 years, if you have served on a state bar committee, if you have a partner who's on the Board of Trustees, if you're connected with the state bar, you're obviously someone whose investigation will not be handled by the Office of Chief Trial Counsel because there's a appearance of impropriety, right? So they actually, under the rules of procedure, the 2201, those are 2201 cases, meaning they are sent to outside special deputy trial counsel, not handled by Office of Chief Trial Counsel. So these, many cases involving Tom Girardi would not have been handled by Office of Chief Trial Counsel, not by the hardworking line deputies and investigators in Office of Chief Trial Counsel, but again, pushed outside of that organization to these special deputy trial counsel. Who picked those? Even though, as your question said, there were multiple chief trial counsels during this time period, there's remarkably solid consistency in who controlled the executive director's office for, up until very, very recently. And the people that are in the executive director's office now are there because of the same people that ran the bar all the way through this period. Meaning Bob Hawley was the one that controlled, as the deputy executive director, all of the assignments for chief trial counsel. So if they were auditing live closed files, they would have been outside of Office of Chief Trial Counsel investigation files. So nothing about the mishandling of those files would say anything about the procedure that is in place for handling trust account violation cases by the hardworking investigators and trial counsel in Office of Chief Trial Counsel. So here it is, apples and crates. These are investigations that were botched or maybe given to special deputy trial counsel to deep six them, who knows, but they were mishandled. If there's missing client money, this is not hard to prove. You know how the state bar proves it? This is all they have to prove misappropriation, is that here is the amount of money that needs to be maintained in trust based on what was deposited into a trust account. And as soon as there's a dip from that amount before the money gets into the client's hands, that's all that you need to show to prove misappropriation. You don't need random audits. You had client complaints, clients who said, I didn't get my money from this or that settlement. So the state bar has, just because you have a trust account in California, they can get a subpoena power to subpoena the trust account records. And that's what's routinely obtained. So if you find where the deposit went in, and then you just trace out where the money went. And as soon as the money in that account dips below the amount necessary for that client to be paid off and any lien holders, you have a misappropriation. So those investigations, which are not difficult, you do not need a forensic accountant for that. Those were botched by some outside special deputy trial counsel.
So it doesn't sound like it doesn't sound like it was a very high bar to
prove misappropriation is not usually very difficult, because if you, let's imagine, had a settlement for 100,000, you pay yourself, because as soon as your interest in those funds becomes fixed, your 40% comes out. That leaves 60,000 left to pay the lien holders and the client. So clearly there's going to be some time lag because you have to resolve the liens, Medi-Cal, whatever it is. But at some point, if the client says, I didn't get any of that 60,000, then the attorney obviously gets a chance to provide their evidence. But at the same time, usually they're already sending out a subpoena for the trust account. So there's nothing in the mishandling of these investigations that would warrant random audits of hardworking lawyers out there. And that is exactly what they're using this for.
I see. And Erin, I had a follow-up question. The involuntary bankruptcy of Tom Girardi was filed on December 18th, 2020. Per the State Bar of California attorney profile, Tom Girardi was not ordered inactive until March 9th of 2021. Notice of disciplinary charges were not brought until March 30th of 2021. Is that time lag unusual? What's the procedure for an attorney being ordered inactive? And what do you think caused the delay in this case?
Well, we know in between the involuntary bankruptcy in December and the enrollment on an involuntary inactive status in March, there was a conservatorship proceeding in LA Superior Court. And under Business and Professions Code 6007, if an attorney is incompetent, you're legally medically unavailable. Why? Because you're incompetent, because you're under a conservatorship order. You can't practice law, right? You cannot practice law. So that is a basis for it's a confidential proceeding in State Bar Court under 6007 to enroll the attorney who's the subject of a conservatorship order inactive. And so here you have Mr. Girardi enrolled inactive by virtue of a valid conservatorship order. And you have the State Bar through its Office of General Counsel appearing, trying to have the Superior Court set aside a conservatorship order and arguing there, if we don't get this order set aside in LA Superior Court, we can't file charges, because guess what? You can't file charges against someone who's incompetent, literally medically unavailable by virtue of a conservatorship order. Okay, guess what? The judge said pound sand. They kept the order in place, and still the State Bar filed charges, knowing they don't have authority to do that. It's all for show. It's all window dressing.
Wow.
Because immediately, and by the way, it was bounced back by 3 different State Bar Court judges, of which there are only 5 that all recused themselves from handling that case. But it ended up, it's abated right now, meaning the discipline case is abated properly, because it should never have been filed at all, because you can't file charges and pursue charges against someone who's medically unavailable.
Wow.
So everything about this case is outside of process, but the State Bar is continuing to have mistakes made, and yet they're using this as a grounds and a springboard to go after attorneys in general, and I think plaintiffs' attorneys in particular, and probably as a reason to, as you know what they're doing, trying to have non-attorneys and computer platforms provide legal services directly to the public. The State Bar's primary mission is supposed to be public protection, and they certainly are woefully inadequate in that process.
Thank you so much for your analysis, Erin. My next question is for Zev Schechtman. Zev, on April 30th, 2021, the attorney for Robert Girardi, temporary conservator to Tom Girardi, sent an email to the State Bar prosecutor saying that Robert Girardi will not participate in the State Bar proceedings, as he does not anticipate that his brother will practice law again. Do you think that was advantageous to him in the bankruptcy proceeding and in other potential criminal proceedings?
Thank you very much, Eliza. I should preface my answer by noting that I'm not a criminal defense attorney, but I would observe that the criminal liability concerns seem to be driving a lot of the strategy here. At least that's my impression. It's really rare that an involuntary bankruptcy petition gets filed at all. I mean, we're talking a handful of cases, perhaps out of thousands and thousands of cases that get filed in our district every year. I think it's even more rare that you'd have a debtor not bother to defend against the involuntary petition, that he didn't intentionally decline to defend. To me, that suggests that, on one hand, the entry of the order for relief against Mr. Girardi and his firm were inevitable. But it also suggests that Girardi's advised not to say anything. And why would that be? In bankruptcy, if you're trying to benefit from the bankruptcy, most debtors go into bankruptcy trying to achieve a discharge, a fresh start. That's probably not the objective here for Girardi in this involuntary case. It's not a realistic goal. It seems more like they're focused on that his team would be focused on damage control. and making sure that this bankruptcy doesn't develop to be used against him, or limiting the amount that that this bankruptcy case could end up being used against him for criminal purposes. Bankruptcy, after all, is a type of civil action. It includes very strong information gathering tools. While an individual or a company is a debtor in bankruptcy, there are a number of paths to discovery, which include everything from the beginning of the case, which include formal schedules and statements filed under penalty of perjury. There's a meeting of creditors where the debtor needs to testify under oath under section 341 of the Bankruptcy Code. There's a rule 2004 of the bankruptcy rules, of the federal bankruptcy rules, legitimately permits a fishing expedition, which allows for examinations and document production of any entity that has information regarding the business or financial affairs of the debtor. Rule 26 of the Federal Rules of Civil Procedure, the entire thing is incorporated under the 7000 series of the Federal Rules of Bankruptcy Procedure, and can be brought into contested matters, meaning motion practice in bankruptcy. So all of these tools can be used and are being used on a regular basis to develop evidence for civil purposes in bankruptcy. And of course, as we learned in law school, the information that gets developed in a civil case can end up being used against parties in a criminal proceeding. My guess is that the less Girardi and people close to him say or do in this facet of public life, or any facet of public life, is better from a criminal perspective. But we'd have to get a criminal lawyer to confirm that. I think it's one thing to be a debtor with a non-dischargeable debt. It's actually a very different thing to have a felony criminal conviction. I would also, one final note in this regard, there was an individual who was designated as the representative of Girardi Keese, Chris Kamen. I don't know how that name's pronounced, but he's the former CFO of the company, and he apparently invoked the Fifth Amendment in response to all the questions at his examination under oath. Wow. Under section 341A.
Okay, thank you so much for that analysis, Zev. And I have another question for you. With regards to the requirements to file an involuntary bankruptcy, is it difficult to meet that threshold? And who were the creditors here that pushed Tom Girardi into this bankruptcy?
Thank you. Under section 303 of the Bankruptcy Code, that's Title 11 of the United States Code, an involuntary bankruptcy petition can be commenced under Chapter 11 or Chapter 7 by 3 or more creditors with claims that are not contingent as to liability or the subject of a bona fide dispute as to liability or amount. That's typically viewed as a very high and difficult standard, which is the reason why these are rare. Usually you want to see a final judgment to establish this requirement. Anything less than that under normal circumstances would be concerning, because anything less can subject the petitioning creditor to attorney's fees if the petition is denied, and punitive damages for a bad faith filing. You see litigation surrounding those issues because people try to use this strategically instead of under the very limited circumstances provided by the Bankruptcy Code. So again, it's rare to see an involuntary petition filed, and it's rare to see them go unopposed. The closest we saw to an opposition was not really an opposition, but Robert Girardi filed a motion to extend the time to file a response, which was summarily denied. So yes, it's a high bar, and here the initial petitioning creditors were a number of vendors, parties with contracts and other types of breach of contract claims. Other creditors joined the petition, and they filed a request for judicial notice that contained really overwhelming evidence, millions and millions of dollars of various money judgments, pre and post judgment orders for remedies such as attachments, and probably the most compelling and disturbing fact that is common knowledge at this point is the claims of airline victims and other former clients who were owed millions of dollars in settlements or judgments, which were never paid. And of course, this all came to a head when the federal district court judge in Illinois froze all the assets of both debtors and essentially made these involuntary petitions a fait accompli. Shortly after the bankruptcy petitions were filed, within a matter of days, the petitioning creditors filed a motion on shortened time to appoint trustees in both cases. That was Christmas Eve, December 24th. On January 5th, which is barely 5 business days later, the court held that emergency hearing and immediately appointed trustees in both cases. I describe these facts because they're so unusual and reflect the urgency of these cases. And then likewise with respect to the entry of the orders for relief. The summons that was quickly issued after the petitions were filed required a response, an opposition to be filed by January 12th, 2021, and set an initial status conference for February 16th, 2021. No response was filed by the January 12th deadline. And on January 13th, the very next day, the court entered an order vacating the status conference and directing the clerk to immediately enter an order for relief, putting the nail in the coffin of this involuntary petition, continuing and to this day still being managed by 2 separate trustees, one for each debtor.
Thank you so much for that insight, Zev, on involuntary bankruptcies and on this one in particular. Okay, now we're going to shift to family law. I know everyone's wondering, everyone has lots of questions about the divorce filed and what's going to happen to Erica Jane. So we're going to shift our questions to Demetria Graves. Demetria, in a bankruptcy proceeding, having a debtor under a conservatorship doesn't affect bankruptcy proceedings so much because there is already a trustee assigned. How does the family law court and related family law proceedings look? How do they look when one of the parties is under a conservatorship order, like in the present dissolution proceeding between Tom Girardi and Erica Girardi?
Well, thank you so much. I think the family law proceeding is very different than the bankruptcy proceeding. Essentially, the conservator steps into the shoes, in this case, of Mr. Girardi. So all the documents that are filed will be served on his conservator. The conservator is responsible for filing any responsive documents, attending any court hearings, making sure that the conservatee, Mr. Girardi's interests are filed. As it stands right now, there's not much going on. There's been a stay in the case, meaning that there's been notice made to the family court that a bankruptcy is going on. So there's nothing to do at this point. But when the bankruptcy is over and the parties resume, and we will see if that actually happens, then the conservator basically stands in the shoes of Mr. Girardi and will handle the process.
And have you seen these kinds of cases like stay open for a very long time until, let's say, a bankruptcy is, until it's completed?
Right. It's not uncommon to see that a family law, at least part of the family law case, is stayed while the bankruptcy is going on. The family court is really, really good at acknowledging that there's a bankruptcy and letting the bankruptcy run its course. It gets really complicated sometimes if parties, and I've seen parties file for bankruptcy in the middle of a dissolution. And so that can get a little messy. But here it looks like Ms. Jane filed the petition and nothing else has been done. So it stayed at this point. No one, I don't even think Mr. Girardi filed a response. So until the bankruptcy is done, I don't think we're going to see much on the divorce portion.
I see. Okay, and then some other questions about the marriage of Tom and Erica Jane. These questions are for Demetria and Zev. Let's start with Demetria. So Tom Girardi and Erica Jane were married for 21 years without a prenup. What does that mean as far as ownership of assets and liability for debts incurred during the marriage?
Well, presumptively, from the family law perspective, whatever was incurred during the marriage, the assets and the debts are community property. So at the, the family law level, they are responsible for sharing both the assets and the debts. My concern for Miss Jane is she didn't join Mr. Girardi in the bankruptcy. So she is on the hook for that. And I'll let Zev speak more to that. But from a family law perspective, they are both responsible for the assets and debts incurred during the marriage. And I believe Miss Jane listed the date of separation of November in 2020. So technically speaking, from the family law perspective, that's when the responsibility ends. But during the whole 21 years of their marriage, they are both responsible.
So she's going to be liable for his debts, even though she filed for divorce before he filed his bankruptcy.
Presumptively. So, right, presumptively, she is responsible. And even if they're discharged in a bankruptcy, that doesn't mean that that's going to stop the creditors from coming after her. So the debts would have to actually be assigned to Mr. Girardi for them, and that sometimes doesn't stop the creditors. So I'm not sure what she's going to have to do. It appears the bankruptcy court has sued her for $25 million. So I don't know if bankruptcy is in her future, but I will let Zev speak to that.
Okay, and Zev, do you have any thoughts on the ownership of assets and liability for debts incurred during the marriage as far as from the bankruptcy court's perspective?
Yes, thank you, Eliza and Demetria. The filing of a bankruptcy petition creates a bankruptcy estate. That bankruptcy estate is made up of all property of the debtor as of the time that the petition was filed. Property of the estate, of the bankruptcy estate, includes community property. In Chapter 7, which is where we are, the trustee liquidates property of the estate for the benefit of creditors. Again, property of the estate includes community property. And Girardi's in Chapter 7. So thus, under black letter bankruptcy law, any community property of the Girardis needs to be turned over to the trustee. And the trustee is going to liquidate that asset. So just to make up an example here, if Erica Jane Girardi drove a Bentley purchased with community funds or purchased during marriage, that would ostensibly be an asset of the estate, and she'd have to turn it over. Now, if there was any equity in it, if that Bentley had some value, the trustee would take the asset, would liquidate it, and put those proceeds right into the funds that would end up being used to pay creditors after expenses of administration get paid. So that's just a little bit of how community property is dealt with under the bankruptcy code.
What about like jewelry? What if he gifted her jewelry during the marriage? Would that be property of the estate, or would that be considered separate property?
Well, you do have to look at state law to determine what is and isn't community property. So we would defer to California state law on that issue. But there's other theories that we'll probably hit on what the trustee can do to recover assets. So fraudulent transfer would be the most obvious if in the last 4, 7, or 10 years, depending on which statute you look to, she received these gifts. Those are likely, based on what we know thus far, there's at least a colorable claim that those would have been fraudulent transfers. And perhaps worse, perhaps we're not even talking about bankruptcy avoidable transfers. If it's stolen property, that's a whole other area of law that would be a basis for recovery.
Okay, great. And then I have another question for Zev. I think everyone is wondering if Erica Jane knew about Tom's conduct. We actually have a question by one of our audience members. So could Erica Jane's knowledge or lack thereof affect the trustee's ability to, recover assets that were transferred to Erica Jane from either Tom Girardi or Girardi Keys? Is her knowledge relevant?
It may be, but it's probably not front and center on the most straightforward kinds of claims. For the common civil bankruptcy claims against Erica Jane, again, fraudulent transfers under Section 548 of the United States Bankruptcy Code and similar provisions of California law, lacking knowledge for a transferee, for the initial transferee, is generally not a defense. Same goes for turnover of estate property. If she's in possession of property of the estate, that's a pretty cut and dry type of claim. It doesn't require knowledge. You can be completely innocent and be a recipient of estate property or of a fraudulent transfer. It's not even necessary that the transferor, the debtor, intentionally defrauded creditors, because there's a whole statute and case law surrounding constructive fraudulent transfers, which are, generally speaking, transfers from the debtor that were made while the debtor was insolvent without reasonably equivalent value in return. And so knowledge isn't really that important for the most common types of claims, although again, I'll leave it to the criminal defense attorneys to address in another presentation whether and to what extent knowledge would be relevant for those purposes.
Thank you so much, Zev. So back to Demetria. With the current state of Tom Girardi's affairs, is this a scenario in which a prenuptial agreement could have actually been beneficial to both Tom Girardi and to Erica Jane?
I don't think either party could have imagined what was to come down the pipeline 21 years ago. So I'm not really sure a prenup would have saved these two. A prenup is a great tool to outline for the parties the division of debts and assets. And what may have been helpful for Ms. Kane is a discussion of separate property income. Because technically speaking, after the parties filed for divorce and the date of separation, her income from Real Housewives of Beverly Hills or whatever she does is her separate property, but that also could have been outlined in the prenup. I doubt she would agree to that, right? Because she wasn't the higher breadwinner at the time. And this could have outlined debts as well, that any party incurring debt, that's their personal debt. However, I don't think that has much bearing on the bankruptcy court and the lawsuits that are coming down the pipeline. So I'm not really sure if a prenup would have helped these two, especially in the state that they're both in.
Okay. And Demetria, can you discuss with us a little bit the pros and cons of initiating a dissolution of marriage prior to a bankruptcy filing?
I think Ms. Kane wanted to attempt to distance herself from everything that is going on and to probably primarily show the bankruptcy court, I didn't know about this. I'm divorcing this man. I want nothing to do with this. And I think there's a way to kind of shield her from everything that's happening with her soon-to-be ex-husband. As I also mentioned, any property incurred after the date of separation is presumptively the separate property of that spouse. So she might also be attempting to protect her income that she's receiving, especially that Mr. Girardi is probably not receiving much at this point in time. So I think it primarily was to distance herself and to protect what income she does have coming in.
Okay, well, thank you so much, Demetria, for giving us that family law perspective on this case. And now we just wanted to take a moment to thank our sponsor, Marcus Cusick and Cusick Insurance Brokers, who made tonight's events possible. Marcus is the principal at Cusick Insurance Brokers, a trusted risk advisor and insurance broker for law firms throughout the nation. So Daniel, can you bring Marcus on? Marcus, you need to unmute yourself.
Okay, yeah, thank you. When you invited me in, it has me rejoin and it seems to lag for just a minute there. So
No problem.
yeah, hey, thanks. Just wanted to take a minute. I'm really glad to be a part of this. I've been really interested in kind of what's happened with Girardi since I first read some article in the newspaper. I think it was early in 2021. Just I couldn't believe that this actually happened and went down the way it was saying. So I've been following it pretty closely since then. And I'm an insurance broker. We do lawyers malpractice insurance and employment practices liability, and more recently cyber insurance for law firms. So I've always been kind of interested in legal ethics and lawyer discipline and rules of professional conduct. And so in my experience, my mind was blown when I read how this actually went down. So yeah, really, really glad to be a part of it. And to, I think I registered just as an attendee because I was so interested in it before the opportunity to sponsor even came up. But yeah, happy to help anybody out with the malpractice insurance or other insurance for their firm. You can I'll put my email address in the chat and shoot me an email anytime, even after this is over. Just let me know when your policy expires, the month, and I can put you on my calendar and check in with you then. And happy to connect with anybody on LinkedIn, Instagram, or Facebook. You can find me there, and I'm pretty active in talking to lawyers about managing their risk and growing their firms and protecting their firms from catastrophes like this. So really glad to be a part of it. Thank you.
Thank you so much, Marcus. Okay, and our next question is for Zev. Zev, does Erica Jane's filing for divorce 1 month before the bankruptcy have any impact on the bankruptcy trustee's rights to avoid transfers of assets by Tom Girardi to her during marriage? I think we touched on this, but if there's anything that we missed, if you wanted to discuss that.
Sure. I mean, the short answer is no. The divorce doesn't move the needle at all, really, as far as I can tell. The transfers at issue occurred during their marriage, and under California law, there's some precedent that, at least under federal law, if there's IRS claims involved, as I'm sure there are here, you might be able to reach back as much as 10 years. The basic bankruptcy code statute provides for 2 years. The bankruptcy code incorporates California law, which allows for 4, sometimes 7 years. So we're really looking back to a period that they were married. And even if they weren't, it wouldn't have made a difference because if she's the recipient of a fraudulent transfer, doesn't matter if they're married. That can be a relevant factor, but it's not gonna save her or not. I think what's probably more important here is collectability rather than liability. These are really issues for forensic accountants. Was Girardi insolvent? Was there any reasonably equivalent value given to the estate? It's hard to imagine that there was, but really, what I'd be interested in knowing is where did the money go? If the answer here is that they all went into these sort of vanity projects, music videos, and parties, other things that probably disappeared, that are no longer have any discernible value. There really may be really may not be much collectability, or there may be collectability issues. I think what the trustee will probably be looking at is whether Miss Jane owns anything of value, and that's the kind of thing that the trustee is going to be looking for. Whether or not they were, the timing of their divorce is probably not going to make a big difference.
Okay, and related to that, as far as the allegations that Erica Jane received $25 million, if she doesn't have that money anymore, what can the trustee do as far as collectability goes? Can they just get a judgment against her and then wait and collect from her future earnings? Do you think that there's a bankruptcy may be inevitable for her?
If you took Tom Girardi out of this whole story, and it was just Erica Jane's debt at issue, she might be a candidate for Chapter 7 because her debts are not primarily consumer debts. So if she filed for Chapter 7, she would get an immediate. Typically when you file a Chapter 7, if you don't have certain types of issues, you can get an immediate discharge and you're entitled to all your future income. That's assuming her debts are primarily not consumer debts. But alternatively, she'd have to do a Chapter 11 or Chapter 13, probably Chapter 11 plan, which would mean having to come up with a payment plan where she pays creditors over 3 to 5 years and then gets a discharge. But given where she is in this situation, it's hard to imagine that she would have an easy time getting a discharge. If she filed for bankruptcy, what would be her exit plan? How would she be able to use she is Erica Jane Girardi, as much as she might prefer the name Jane at this time. And creditors are likely to pursue claims against her for non-dischargeability. I think it's a good question to ask, what is the end game for the trustee here? Trustees are typically looking for an economic resolution. They want to see money flowing to the estate. And so the trustee is likely to look at issues of collectability. If she is able to establish that there's only so much that she'll ever be able to pay realistically, based on current projections, she may be able to come up with a settlement with the trustee that would result in payments that would resolve those kinds of claims. I think I don't know, but I imagine that the trustee is trying to figure these questions out right now through the process and see what the future is for in terms of collectability, so that they can reach that resolution. And otherwise, it's an expensive trial and litigation process without clarity regarding a pot of gold at the end of the rainbow. Again, there's dischargeability risks in bankruptcy that a creditor or a debtor in her position would want to avoid, to the extent that the debts were incurred through fraud, willful and malicious injury. There's certain types of restitution, non-dischargeability issues. So right now, given the situation, it seems like a client in that position, you kind of want to wait and see how things shake out. Filing bankruptcy today would potentially get her temporary relief through the automatic stay. When you file for bankruptcy, all litigation against you stops. But if that's all she gets from it, a temporary stay, it doesn't make bankruptcy very attractive.
Got it. Thank you so much for that, Zev. And I have a question now for Brian. Brian, in the documentary, The Housewife and the Hustler, which we saw a clip of, some of Girardi's clients alleged that Girardi invested millions of their dollars of settlement funds, and they saw very little of that money. Is investment of client funds something that's regularly done amongst the plaintiff's bar, or is this frowned upon?
So let me first go back to what Zev was just talking about here. And I want to mention that this is a very unusual situation, I suspect, Zev, in bankruptcy cases, because a plaintiff's lawyer's inventory, so to speak, are those cases that haven't settled or gotten a final judgment on yet. And the Girardi situation is interesting because his firm does have a lot of cases in their inventory, which have now been parsed out to other lawyers, where they're going to recover money at the end of the day. And there's some pretty optimistic numbers that are being floated around. So this may be in a state where some of the creditors get some of their money. And that's probably a good thing, but it's important to understand that the plaintiff's practice operates that way. Anyone who has a hefty plaintiff's practice, like I do, and I've looked at the list here, and some of our folks listening into, you have an inventory that is valued and is someday going to presumably come due. So now on to your question about, do lawyers have a situation where a case settles? So the case is settled, there's a large settlement. My client is supposed to get some money out of this case, and I am going to now take it upon myself to invest that money so the client can do better, or it can do well, because I'm investing. I'm going to manage the client's money. And the question is that sort of typical, or does that happen? And the answer is never. Let me be clear. Never. It is insanity. If you decide to do that, you should make 2 trips immediately after you decide you're going to invest your client's money. One is to the state bar to turn in your state bar card, and the other is to the Atascadero State Mental Hospital to check yourself in. And then maybe you fall under 6007B of the Business of Professions Code because you've lost your mind. It is not uncommon in cases where clients get a recovery that you set up a structure, or you get a professional fiduciary to manage the money. But first of all, and Erin's certainly in a better position than I am to tell you this, but first of all, you're now taking on a whole different role with your client, for which you'd need disclosure, for which you'd need them consent. And I don't know why any lawyer would do that, particularly when there are professionals out there like structured settlement, and this is where the money goes into an annuity, or it goes to an investment counselor. Because the minute you take on that responsibility yourself and you're going to invest the client's money, you've become a different type of fiduciary. And if you screw up the amount of money that the clients have, so they've got, let's say their settlement net is $1 million, and you are now going to take that and invest it, you're pretty much on the hook for that $1 million if something goes wrong. So it never would happen. It is not something that anyone would do. That in and of itself is a red flag. And I know I've seen questions pop up on our screen here, both in the chat function and the Q&A function. I hope we get a chance to get to some of them. There were, clearly early warning signs here that people knew, or some people knew, but this whole notion of I'm going to invest your son's money for you, or whatever the words were in that particular letter, is a giant red flag. I think that a good, smart lawyer will steer a client to a professional, whether it's to set up a special needs trust. There are professionals who do that for a living. Whether it's to set up an investment, whether it's to set up an annuity, there's professionals who do that for a living. So in the broader context of trying to educate folks about this, never do that, or turn in your state bar card, go to the Atascadero State Mental Hospital, or it's a warning sign for something, something going on. And he's not the only one, because I believe there are allegations in Avenatti's case that the same exact thing allegedly took place, that he was making promises about investing the money. Now, I say that's alleged because I don't know for a fact, but it's a sticky area. You'd never want to get into that.
Yeah, I mean, I've never heard of that until I saw the documentary. So I was pretty floored. And thank you so much, Brian, for sharing your insight. So I guess, Erin, I think I know the answer now that Brian shared it with us, but if this was not, is this allowed? Are you allowed to invest your client funds? And if not, was this just a brazen act by Tom Girardi? If he did in fact do so.
This is the thing, and this is why what Brian just said is exactly correct, because before you have an attorney-client relationship with some potential client, it's an arm's length transaction. So your fee agreement with the client is negotiable, because even if you're the lawyer and they're just the client and you're the one with the legal experience, we allow you to negotiate with that client whatever the terms are, because everybody's fee agreement has that this is negotiable. It's not set by law. But once you become the attorney for that client, you have a special fiduciary relationship. Any business transaction you have with the current client has to comply with Rule 1.8.1. And of course, most of these transactions happened under the former rules, but it's the same principles. The very first important point, if you're entering any kind of business transaction with a client, is what? Fair and reasonable. It has to be objectively fair and reasonable. So there are discipline cases where attorneys have faced significant discipline up to disbarment by doing these to themselves, no interest loans from the client, or a really famous case where the attorney used the money to buy racehorses, which did not work out well for the clients. Okay, fair and reasonable. And then even if it's fair and reasonable, you have to have the client giving the opportunity to get independent counsel. And so they either get independent counsel or they acknowledge that they had time and a right to get independent counsel, and you have informed written consent. So without compliance with 1.8.1 or the prior rule, you already have a very serious disciplinary violation, which could result all the way up to disbarment, especially when you put on the other facts here, which is the overreaching of here's vulnerable client money. How do we know they're vulnerable clients? Because they were the victims in some kind of horrible accident that resulted in those proceeds. And you, as their attorney, come to them and say, I'm going to invest this money so that you'll have a stream of income for the life of your son or your child or your own self. Oh yeah, the racehorses case is a real case. I wish I had the site off the top of my head, but text me or email me and I'll be happy to share that with you. So there is no way you should enter a business transaction with the client ever. And if you do decide to enter, there are also cases where no good deed goes unpunished, meaning you can have a situation where you start out with the case that's like an hourly case. And let's imagine your client, the case is going on, but the client ran out of money. Don't forget, you're already in that fiduciary relationship with that client. So if you're going to renegotiate a fee agreement here, you're going to go into some kind of modified lower hourly or even a contingency at that point. You still have to comply with 1.8.1. And if you don't fully comply, guess what? If you decide to do on a handshake, stop collecting fees for 2 years because your client can't pay you anymore because they ran out of money. And at the end of the day, they don't want to pay you the contingency you all agreed on. That's a violation. You can't collect a contingency fee without a written agreement. And so I've actually had discipline cases like that. So the truth is, once you're in that relationship with the client, you have to have full compliance with 1.8.1 before doing any kind of business transaction, even a zero interest loan to the client, like to pay their own expenses because they can't pay their rent and they can't pay their own living expenses waiting for that case to settle. You can't give them a zero interest loan unless you fully comply with 1.8.1. You can be disciplined for that, even though you were trying to do a humanitarian act.
Wow. Well, thank you, Erin. And I think you might have already answered this question. But basically, in the same announcement in which the State Bar admitted mistakes were made in the Girardi investigation, the State Bar announced that it might require regular independent audits of attorney-client trust accounts. So I think you kind of already covered this, but I guess my question is, do you think that this would protect clients, or would this just be another regulatory burden for lawyers?
Let me answer it this way. In 2015, the State Bar was in crisis because of the high backlog. Backlog means cases that are pending for 6 months or more. So they made many changes in the processes in Office of Chief Trial Counsel in 2015. As of the state audit in April of 2021, which audited the State Bar for their performance between 2015, when they were already in crisis, up to 2019, guess what happened to backlog? Backlog increased 87%.
Wow.
And their case handling time more than doubled. So what's happening in Office of Chief Trial Counsel now is doubling the case handling time. It is increasing backlog 87+%. And what they don't tell you is that it's also increased the losses in State Bar Court. They're forcing attorneys to full charges to defend themselves. And they are getting defensed, meaning full charges dismissed on about 20% of the cases that are handled on the merits. So they're not taking care of actual client complaints that are coming in right now. So how is random audits with that same staff, it's already stretched thin with investigators with caseloads of over 100, most of them backlog, meaning most of them over 6 months old. How is adding random audits going to protect the California public right now that have already filed actual complaints about what they think are misdelivery of legal services? No, this is another boondoggle by the State Bar. They're always about, look at this bright, shiny object in the corner instead of our own horrible numbers and performance in the moment. Major changes need to happen in Office of Chief Trial Counsel, and it's not random audits. Thank goodness we've just, after 5 years, the Board of Trustees just appointed a new Chief Trial Counsel, the first serving Chief Trial Counsel in 5 years. Someone different that wasn't part of the reorganization that created the problems that they're facing today. So hopefully they're going to be taking that into account and make some major changes. And I can tell you there is some good signs, because the Board of Trustees has a ad hoc committee going on right now examining the efficacy of OCTC, Office of Chief Trial Counsel, and hopefully they're going to recommend some major changes. And it won't be random audits, which is going to take them off their mission. It's going to be actual proper case handling.
That's great. That's great to know. Thank you, Erin. And Erin, as a follow-up question, how can lawyers best ensure that they are in compliance with the rules of professional conduct with regards to trust accounting? Should they regularly consult with an ethics attorney? Should they regularly audit their own trust accounts? Do you have any other advice?
Well, first of all, you have to have mandatory monthly reconciliations of your trust account. If you have a very busy practice or you have a very slow practice, it doesn't matter. Your trust accounting is a non-delegable duty. But if this is not, you don't have to be a computer wizard to do decent trust accounting. If you have almost any one of the available software, QuickBooks, Quicken, any of these kind of programs, especially if they're connected to a case management software like Clio, which is the state of the art, or Practice Panther, many of them already do the accounting for you. But you can't rely just on that software. You have to always reconcile to your bank account to make sure every month that you have the monthly reconciliation, you have client ledger card, and it's no longer a card like it used to be, a little cardboard card. It's really just a report which shows that, in your IOLTA, it has a bunch of different clients' monies all commingled, which is totally okay. That's the reason why we have IOLTAs. The idea is if money is going to be transitory running through the account such that it wouldn't be there long enough in any particular account to cover the bank charges, the interest on it, that's why we're allowed to have the IOLTA, interest on lawyer trust account. So the idea is you need to know at any given time, if there's a balance, let's say of 100,000 in that account, how much of it belongs to Mr. Baker? How much of it belongs to Mr. Edgar? That's what the client ledger card is. Every in, every out for each client shows up on the client ledger card. And if you keep decent QuickBooks up to date, you're not going to have a problem doing that. My strong suggestion, because I deal with a lot of people that have the trouble, they get the letter from the bar and they're like, I never balanced my trust account. Sad to say, but many years into it, that happens. You have to have those records. And at that point, you need to recreate those records before that response goes in. So getting a good bookkeeper, even an outside bookkeeper who works with a lot of different law firms, is a great way to make sure you're in compliance, and it's not a huge expense. So even if you have a small practice, that is money well spent, having someone back up your data, making sure that you're always on top of your trust accounting.
Thank you so much, Erin. And my last question is for Brian. Brian, your firm handles cases with multi-million-dollar verdicts and settlements. Is there ever an excuse for an attorney to remove unearned funds from his or her trust account?
So I think it's important, though, to distinguish what Erin was just talking about. And I think what happens with a lot of lawyers is carelessness or lack of accounting skills or lack of a professional staff to help them. And, my heart goes out to the solo practitioner who might just goof up something and then the state bar comes after him. And I've heard from Erin, and, I'm very close with Ellen Pansky, who's another fine defense lawyer representing people. And I hear constantly about how, somebody's just made a mistake. I want to distinguish that from what we've been talking about tonight, which appears, at least on its face from the evidence we've seen, to be a deliberate misappropriation of funds. So let's kind of put those into two separate compartments here. The lawyer who simply wants to do a good job and makes mistakes. And I do want to go on record saying that, one of the reasons I became a lawyer and not a doctor is I'm terrible at math. And fortunately, I think I was one of the last classes at USC where, as an undergrad, they didn't require math. Otherwise, I'd be, doing something else. It's really important to understand that there are people out there that are professionals that can help you with this. And it's the old story of a few bucks here and a few bucks there. My mother would say cheap is expensive and expensive is cheap. And getting a good accountant to help you with your trust account, reviewing it monthly, understanding those kind of things is really, really important. But I think that kind of moving on from that, understand one basic rule right off the top of the bat for everybody to understand is the client money is not your money. It never is, never was. It's not your money. And the smartest thing you can do is get that money out to your clients as quickly as possible. So, if that's kind of the rule of thumb you go by, which is I want to get the clients their money, you're entitled to your fees. That's fine. You have to get their authorization for the distribution of costs. That's fine. But there's some amount of money that goes into that trust account. And as soon as it clears, get that money to your clients as quickly as possible. If you're trying to do a good job, and Erin probably can answer this better than me, but I don't think the state bar cares. You can already tell from my presentation tonight that I'm no big fan of the state bar, but I don't think they care if your excuse is I was careless or I was misappropriating. What they look at is the simple accounting issues. And if they see that you took more money than you were entitled to, you took client funds, or you took money you weren't authorized to, you can be in big trouble. So it's really worth it to do the right thing. Now, sometimes we get into cases where we have multiple plaintiffs. I've got several cases where we've got hundreds of plaintiffs. And in those cases, we use a third-party administrator to help with the trust account. We have a professional fiduciary. Sometimes it's a smaller number, but it's a lot of money. We get a professional fiduciary. And you don't have to have an IOLTA account if the money's going to be there for a while. You can set up a special standalone account. We'll do that sometimes in cases. You will come in, if you practice plaintiff's law long enough, you'll come into contact with every kind of scenario that you possibly can. But I just want to go back to what I said, is that we're talking now about preventative measures that those people, and I'm sure that all 160 or so participants tonight are these people who have the right in their mind, in their heart, to do the right thing, to get their clients their money. Do what you can, put in layers of protection, get professionals out there to be watching your account and checking it with you. It's well worth the money. It's well worth the investment. But what we're also talking about tonight is the deliberate misappropriation. And I think that, a line has to be drawn there to talk about that. So when you talk about the deliberate misappropriation, Erin and I are completely in agreement on this, that coming up with some notion of, random audits or monthly reporting or annual reporting of your trust accounts, it is just a giant mistake. But, someone out there is going to say, well, wouldn't that have caught Girardi? Well, theoretically, but for the fact that there are allegations that he had an in at the state bar. I've seen so many terrific questions pop up on the screen in the chat box. And I know I'm not trying to hijack your role here, but if you can try to drop those into the Q&A section, we'll do our best to answer. We'll try to answer as many of these questions. I've seen some directed at me that I'd like to be able to try to answer as well tonight. So I hope that answers your question. I'm just telling people, especially younger lawyers or your lawyers that are just starting out in this PI world or the plaintiff's world or the contingency world, this is where you can find yourself in the biggest trouble. And it's the easiest, if you have a good heart, it's the easiest to protect against by putting in safeguards.
Thank you so much, Brian. And I wanted to thank all of our speakers tonight for sharing their valuable insight on this case. We really appreciate everyone attending, and we do have time to answer the audience's questions. So I'm going to hand this over to Dan so that he can field the questions.
Okay, there's a ton of questions, and I certainly have some of my own. Brian, let me come back to you here. Why don't we just get some hard and fast rules on what the law is insofar as maintaining your clients' funds and trust goes? So first, most basic question, at what point can a contingency fee attorney take the fee once the money is in the trust account?
I take the position that my fees are earned when they're paid. So if a settlement comes in, it's $100,000 and my fees 33 and a third or 40%, $40,000, for example. And the client has never raised an issue. The client has never said, I'm disputing your fees. I think you're getting paid too much. I'm angry. You're entitled to your fees right away. Similarly, the client is entitled to the undisputed portion of their money right away. Also, the safest safeguard is before that, there's always a lag time between the case settling or the judgment coming in and the money being paid or the money clearing. Do everything you can to get a disbursement sheet out there and get the clients to sign off on it.
Well, let me ask you this, and let's go into even more detail. As you know, sometimes there's liens, there's subrogation issues. Let's say you got the $100,000 from your client, it's sitting in the trust account. At that point, based on what you've said to me, it sounds like you could take your third or 40%. But what if there's Medi-Cal liens and subrogation issues?
Well, you have to be very careful in those situations because there are certain federal law and rules, and you certainly know it as well as I do, Daniel, that lawyers can be liable for not satisfying certain liens. There are safeguards. I don't want to get too far afield tonight, but try to do everything you can to make sure that those issues are resolved before money starts getting distributed, or that they're at least settled. They're settled, and there's ways to do that before the money comes in too, if you can.
Would you say, and this is the last one for you, Brian, would you say best practices is to hold off in terms of financial distribution till all the subrogation liens and stuff like that are taken care of?
Well, or until you're reasonably certain. I mean, if you understand that let's say there's a $10,000 claim out there by somebody and there's $150,000 sitting in the account, you can take your fees. As the client understands that the $10,000 is going to have to be set aside, you can certainly do that. Look, no one will ever criticize you for putting too much in writing, right? So if you get the client sign off, you disclose these facts to the client, you disclose them to the subrogation lien holder what you're doing. No one's going to come back and criticize you later.
Okay, fair enough. Demetria, let me ask you a question. As I understand it, Erica Jane is still on the television show. What impact could this have on the divorce proceedings?
I would say that his conservator and their family law attorney will be watching the show in great detail to see what she says, what she has, where she's living, all of her assets, everything, even the bankruptcy court. They're going to be paying really close attention. She did a great job of saying where she was going, everything she had. I don't know if that's going to change much. And from my understanding, they have subpoenaed a lot of the old footage to see her assets, her debts, everything that's going on. I don't know if it's a good idea for her to even be on the show, but at this point, how else would she make her money right now?
Yeah, I would love to be in some of those state bar or bankruptcy hearings where they actually have to watch the Real Housewives of Beverly Hills. That would
be great. I'll do that part.
That could be fun.
Yeah, I would chime in on that and say that it's not advisable to be on TV. The problem is, and I think I read within the last day or two that she since they renewed for another season, she's getting $600,000 a year. Right. And there's really, since her husband's not stealing from clients right now to fund her lifestyle, there's really no other way for her to pay for her lawyers and other expenses. So, it's kind of a difficult proposition because she's obviously under a lot of financial pressure, but she probably needs that money to deal with those financial pressures.
I want to add one thing, if I can jump in here too,
Please.
About the Real Housewives, and just to get on my soapbox here for a minute. One of the reasons I did the documentary in the first place is because I thought it was important that somebody from the plaintiff's bar, somebody who's in a leadership position, get out in front of this, like we're not circling the wagons around Girardi and company. And I watched that Real Housewives a couple times when it first came on, when she was first on there. And, frankly, and I'm going to sound too preachy here, I thought it was disgusting. I thought the waving in the face of people, the wealth, the money that was had. Look, I've been a successful lawyer. I have a lot of colleagues who have been successful. We don't need to put out there for the public how much money we made or how successful we've been. I'm afraid that, that Instagram and social media platforms are at one level, but the Real Housewives, it was really, if you look back at this now, the warning signs that were out there about what was going on. And certainly people may have known or did know. And I think the Real Housewives was another factor that took it to a different level. Just my opinion, folks.
Well, I have to say, but that's what Real Housewives is. It is showing the world how much money you have, your status. That's what the show is. So the fact that she signed up let me know that she wanted to showcase that to the world.
Right. But that's fine, for her point of view. But when he got involved in it, and they started talking about their assets they have and their homes, and from the standpoint of somebody whose life is allegedly dedicated to helping people and making people's lives better, to get out there and sort of shove that in people's faces really bothered me. If he was never involved in it and she was just involved in it, I get it. That's the plot line of that show. But, these are my own personal opinions too. I think we've gone too far in the direction, not just in this environment, but we've gone too far in the direction of people, taking in through Facebook and shoving in your face how fabulous their lives are, when a lot of people don't have fabulous lives.
Oh yeah, I totally agree with you, but we live in this world now where everything is about image and not necessarily what you have. So someone asked, am I aware of how many housewives filed for bankruptcy? Yes, because just like social media, we only see what they want us to see, not what they're actually living, clearly.
Yeah, and I think, look, there's a reason we're getting ethics credits for this particular MCLE. I think Brian and Demetria, you guys brought up some points, and the chat's a buzz about them. Even for me, you take a step back, we all like to announce our settlements. We all like to announce our verdicts. Maybe that's as far as it should go. Maybe that's even going too far. Going and having a reality show certainly takes it to another level. Erin, I want to bring a question over to you about Mr. Girardi and his mental capacity and how the bar looks at that. I'd say I had the pleasure, but in this case, I actually interviewed Mr. Girardi a couple months before this whole thing happened. I went to his office, I saw all the certificates, the awards, of this, of that, and we recorded an hour-long podcast. And to this day, there are still hate comments posted on YouTube on that particular podcast. But one of the things that ended up happening is the video that I had of Mr. Girardi, the podcast, is actually in some of the federal filings. And the purpose of them is to suggest that he is not incompetent. That during his podcast with me, he was competent. And I'm happy to talk about my impression of that. But for a moment, Erin, what does the state bar think in terms of, whatever, maybe you take his age into consideration, maybe you take other things into consideration. What does the state bar think about his mental capacity to make the decisions that he made that affected his clients?
First of all, the state bar, of many of its things that it's not competent to do, it's not competent to determine someone's mental competence. So there's two ways an attorney can be enrolled inactive under 6007 for mental unavailability. One of them is you can actually bring a petition. The State Bar Office of Chief Trial Counsel can bring a petition in the State Bar Court with evidence of like very erratic behavior of a lawyer, and with sufficient evidence, the court can set a hearing and then enroll an attorney inactive, and that is a confidential proceeding. And if it results in an order from the court, it'll be involuntary inactive enrollment, and that's all that will show up on the State Bar profile. The other way is what happened here. You have a Superior Court judge that entered a competency or a conservatorship order. And by having a conservatorship order in place, you're legally incompetent. That's all that Office of Chief Trial Counsel can go on. What happened here is very obvious. It should be. There's egg all over the face of the State Bar. All over the State Bar. So they're trying to misdirect or redirect attention. So they literally brought charges, and if you look at the charges, there's 3 cases in the NDC, notice of disciplinary charges that they filed. They were all ginned up in the end of last year and into this year. And they even include charges for failing to respond to the complaint after Mr. Girardi was already enrolled in active. So they basically, as one of the charges against this attorney, claimed that he didn't respond to their letter, even though they already had him enrolled in active in state bar because of that competency order. So literally, that's how crazy this is. It's so outside of process, it makes no sense. But again, mistakes were made, mistakes continue to be made, and they're using it to, like, bash, all of the hardworking lawyers with, oh, our answer is increase our budget. We need more money. We want to do random audits. That's all they want you to see from this. Not, wow, maybe the special deputy trial counsel program where we can just move cases that are with special folks into the hands of special deputy trial counsel that have no accountability to just go and be closed. Maybe that should be looked at, but they're not looking at that. Instead, they're looking at, let's do random audits on all these lawyers. They're talking about increasing the administrative burden on all of us lawyers. At the same time, they want all these paraprofessionals now to be doing all, full in-court representation up to jury trials, but not the jury trial itself. That's their answer. And you can't make this stuff up. That's how insane it is.
Yeah, there's a lot to be said about the sandbox proposals. And frankly, I think maybe some of those proposals overlap with our discussion tonight. I will have an administrative announcement to make about the state bar's proposals in terms of paraprofessionals, non-lawyers owning law firms. But for now, let's keep the focus here on Mr. Girardi. Let me ask you this, Erin, and then Brian, I'm gonna switch over to you on the same question. What is the state bar doing now to prevent this from happening again?
Well, I've told you. Right now, it's already October. We're halfway through October already. So it's all about, let's get down as low as we can backlog as of December 31st. That's all that they're doing. I can tell you, I just got a new client this week, and the case came in 2019. How can I know? Because the case number has 19-0 and whatever the number is. That means in the intervening 2 years, when whatever that got that client upset in 2018, that resulted in an early 2019 complaint is gone and dead, and they just sent out a letter on it, like in the last week. That's how backlogged they are. I can't even overestimate to you how out of control their backlog is, how they're not taking care of actual live client complaints right now. So we're at a stage where there's a brand new chief trial counsel. They have an ad hoc committee looking at what's wrong with OCTC, Office of Chief Trial Counsel. There's a lot wrong there right now. And hopefully they're going to change the system and make it more streamlined so that really serious cases like misappropriation of funds, that is one of the most serious cases. It carries a presumed discipline of disbarment. And if it's a de minimis amount of money, then you might get actual suspension. So those are very serious cases, and there's languishing in a system where you have very high turnover in Office of Chief Trial Counsel, almost 100% turnover since I left in 2016. So you don't have any institutional memory by design. The managers that are there don't want people that know what's going on to handle the cases. And you have to focus on really, I think, triaging the cases and dealing with the more serious cases with a streamlined, quick approach. It should not be 2 years later that a letter goes out asking for what happened in 2018.
Let me pigtail off that, Brian. Let me bring this to you. After I interviewed Mr. Girardi, and I mean, look, I was excited at the time. It was the first episode of my podcast. I thought it was a big deal. 3 months later, things changed. I reached out to my Cala mentor, and I'm not going to mention his name just because he said something to me. He's old guard. He's been around, and he's like, Daniel, Tom's been ripping people off since I don't even know what date he mentioned. As someone who has such a prominent role in the plaintiff's bar, was there rumors, if not knowledge, if not even certainty of Mr. Girardi's behavior? And if so, when did it start and when did people know about it?
Yeah. So I think the clip that was played at the very beginning of the podcast had me going on the record as saying that for years there were rumors that he wasn't paying his co-counsel, he wasn't paying referral fees. The running joke in town, and it's not so funny now, was that some young lawyer would refer him a case, the case would settle, he'd call up the lawyer, or the lawyer would call up him and say, "Where's my referral fee?" And he would say, "Pal, you're not going to get it on this case because, we didn't do very well, but I'm going to refer you a case. You'll get something down the road." And it was kind of a joke at the time. But the important point here is that these rumors were going on for a while. And then, somebody who I think was a co-counsel of mine in a case noted that we were aware in a case overseas that he was using improper tactics to get cases. Those factors were out there. There were stories in the press about clients complaining. And so there was this whole body of information that was floating around. And here's where I'm going to bring it back to the state bar, which is the one organization that could have synthesized this information and done something about it completely and utterly failed. Now, what aggravates me more about that is that solos and small firms who get, in real trouble for a misstep, and I'm not going to editorialize whether they should or shouldn't get in trouble for that, but they get in trouble for a misstep. They may lose their license, their livelihood. And here was somebody who, if the bar had taken all the information and synthesized it and looked at it and had some, common form of analyzing this information, the problems with the Lion Air Boeing 737 MAX issue may never have come to fruition because it could have been stopped a long time ago. There may have been safeguards put into place a long time ago. And I just wonder how many people out there knew something, and really how many reports the bar had. We've heard rumors that they had a number. There was a long history of kind of lawsuits that were filed against Girardi that were pending in court, people who had sued him, clients and others who had sued him, lawsuits that he had his own person at one point in time in his office who was doing nothing but defending him. And you look at the stories and you put this all together. And I guess what I'm saying is I think it's generally aberrational that this had happened, that there was somebody potentially on the inside, or there was some problem with the state bar not doing this. But it's offensive. And now what I'm worried about is that we're all going to pay the price, right? That the rank and file lawyer out there is going to be under more scrutiny, more accounting, more reporting. And I just don't know where it ends. I mean, I'd like to share the optimism that Erin has, that this new chief trial counsel is going to come in and clean house. But, hope springs eternal, right? I mean, I don't know if it's really going to happen. I think they have to look at deconstructing the bar and coming up with some other alternative, like the AG's office taking over or something, because I don't know if you can really rectify these problems.
Okay, let me take a slight step in a different direction, and Demetria, I'm going to come to you, and then Zev, going to come to you on this one. There are rumors, and I don't like to get into the salacious, but there might actually be legal implications of this. There are rumors of Mr. Girardi having a mistress and some of the funds flowing in that direction. Demetria, what impact does that have on the family law courts?
Well, for purposes of the actual divorce, we have a no-fault state. So why they got divorced, or if there was a mistress, that really doesn't matter. Now, if it can be proven that, he gave these lavish gifts to mistresses and it can be traced and that sort of thing, and gifts over a certain station of life might be at issue in the divorce proceeding. Which reminds me of that. I forget the case. I think it was a Dodger owner or something that was giving gifts to his mistresses. And so if it's over a certain amount, then it might be at issue in the divorce. Otherwise, we have a no-fault state and both parties can control the estate, if you may. So outside of that, it's not going to have a really big impact on the divorce proceeding. Clippers owner, sorry. Thank you for that, Christopher.
Okay. And Zev, from the bankruptcy standpoint, again, I look, I don't know if there's a mistress, if there's no mistress, I don't really follow this, I don't follow that stuff. But from a legal standpoint, should there be one, would that have any effect on the bankruptcy proceedings?
Only to the extent that that any person, whatever their relationship is, has received any property from Girardi or Girardi Keese. So it really doesn't matter what their relationship is. If they received something and didn't pay for it, that sounds like it could be the kind of a transfer that would be avoided. It would have to be a significant sum to be worth pursuing under at least, as described. It sounds like some kind of gift given to somebody with murky allegations. You'd want it to be something like a Bentley, something with actual value, something with equity, something that you can trace. Otherwise, it sounds like you may be going on a wild goose chase. I think what's really more important, I think Brian identified these large types of assets that may actually result in meaningful recoveries to the victims, to the unsecured creditors. We're taught, I think what's really important, as Brian mentioned, is what happens to the litigation that's still ongoing and other major assets of significance. I don't think that anybody's going to be made whole by going after somebody for a piece of jewelry or whatever type of things somebody might have given to somebody under these circumstances.
Okay, thank you for that. Erin, let me come back to you, and then Brian, I'm going to come back to you for tort reform and how this might have an impact on that. There's stories, Erin, about Mr. Girardi whining and dining, and I know we've talked about this, but let's hit the nail on the head here. There's been stories about Mr. Girardi whining and dining the state bar. You have extensive experience at the state bar. What is your take on that? How far did it go? Was it inappropriate, and did it enable the situation that we have at our hands today?
Okay, let me say this. Any case that comes in, a complaint that comes in against someone that is a 2201 attorney, meaning like if a complaint came in against me, it's not about the allegations, it's my relationship having been a former bar prosecutor. If you worked for the bar, if you were on any of the standing committees, if your partner was the bar president, such as Mr. Girardi, those complaints aren't going to be handled in Office of Chief Trial Counsel. They're not. They're going to go to Special Deputy Trial Counsel. So the positioning of those cases into the hands of a Special Deputy Trial Counsel or multiple Special Deputy Trial Counsel that managed to find those unsupported or unsubstantiated, closed, those decisions were not made by the line, rank and file in Office of Chief Trial Counsel. The hardworking Deputy Trial Counsel and investigators that I represented as the union president, I was always a steward. I really worked hard to protect the employees of the state bar because the management was very difficult and honestly wrong most of the times. It's at the high levels of the executive director's office that these decisions would have been made if that were true. No line investigator had the power to deep six or close complaints. It's not possible. It is not possible. The complaints would come in through intake. They're assigned a number, even under the old computer system. They can't get lost, even though there were chief trial counsel in the past that said that their files were lost in drawers. If you look back at the Daily Journal from years ago, that's not possible. It's farcical. So these decisions, if there were decisions that were made to close these cases that should have gone forward, and it sounds like if there's missing client money, that's a legitimate case that should have gone forward, even one of those cases, those wouldn't have been made by the hardworking attorneys or investigators in Office of Chief Trial Counsel. Those would have been made at like the executive director level, where they were positioned off into the hands of Special Deputy Trial Counsel to die and to be closed. That's what would have happened. it would not have been mishandled in Office of Chief Trial Counsel itself. That's what I would imagine, because anyone as connected as Mr. Girardi would not have his complaints being investigated inside of OCTC.
I appreciate your candor about the state bar. There's actually a question. Let me come back to you, Erin, then Brian will come to you on the tort reform. And frankly, Brian, I'd love to hear your opinion on this subject. But there is a message in the Q&A from Leslie Baker, which is, what's the likelihood? And I'm not going to hold my breath, but what's the likelihood that we're actually going to see any kind of ramification, reform, anything at the state bar as a result of this?
Well, I could say this. I do have some hope on this, because I do think that the ad hoc committee that's currently investigating the practices of OCTC are getting really good information, because the party line of the management of OCTC is usually, I need a higher budget, I need more bodies, I can't keep people, because they have very high turnover. That's all they could say. They never look at what is it in their processes that keeps getting such bad results. So are people going to pay the price in this? I'm not certain, but I do know that there have been decisions, or there are requests at the Supreme Court level to do an independent audit of these closed Girardi files, because most people are not satisfied, including the Supreme Court, with this completely internal secret audit by the state bar of these closed files, with the idea that only mistakes were made, that no one's satisfied with that answer. But closed investigation files are confidential and you can't get them ordinarily, but the Supreme Court could. And they could see what really happened here. And I think the same people, the same general management that existed during the time that these decisions were made on these cases is basically what's in power still at the bar right now. That's what I would say without doubt. The current executive director is an appointee who was suggested by Bob Hawley, who was the longtime deputy executive director, who is the one that controlled the 2201 list, by the way, for decades. So the decisions on where those cases would have landed would have been through the executive director's office, not even the chief trial counsel. Although the chief trial counsel would certainly know for sure about those 2201 cases in their existence. There's no way it could be secret. But the line investigator would not know about those cases and would not be handling them.
Okay, just a quick administrative, guys. We have about 15 minutes left to go. Let's try to get another 5-10 minutes of Q&A. If you have questions, guys, please, the chat is great, but it's much easier if you post in the Q&A. That's where I'm reading these questions. Brian, I wanted to come to you, and I know that you touched upon this, and sincerely, as a plaintiff's attorney myself, I appreciate that you're pointing out that solo practitioners might get pinched as a result of the ramifications of the state bar because of this. And maybe not, that's fair. I remember in the 90s, we were dealing with tort reform. And again, I don't mean to put the cart before the horse and talk about the sandbox proposals, paraprofessionals. There is actually a proposal. I'm not saying it's in front of the state bar yet, but there is a proposal that was submitted to the state bar to limit contingency fees, effectively slash them in half. Look, there's always going to be that tension between the business community and the trial lawyer community. But do you think this could have a bigger impact on our plaintiff practice in the state of California?
Yeah, and let me first correct just slightly what you said, Daniel. It wasn't submitted to the state bar. There's actually an initiative that was filed this past week or so, maybe at the end of last week, by business groups, I think the chamber. And it's to cap attorney fees, contingent fees at 20%. They want to get an initiative on the ballot. They've done it before. They'll do it again. And they want to cap it at 20%. And in their press release, they bring up this Girardi situation. So look, this is a terrible idea. I'd love to see corporate America cap their attorney fees, right? If they want to get average ordinary people to cap their attorney fees. But having said that, I think we can use it as an example of what's to come. There is never been, maybe in my professional career, a plaintiff's lawyer that's fallen from grace like Girardi in the way it's happened, especially with the Real Housewives. And it's a national story. If you read the New York Times, there was a story in the last 4 or 5 days about it again. So you can bet that the business communities out there who want to limit people's access to justice, and that's what it is. Let's be honest. It's limiting people's access to a lawyer or access to justice, who will roll this out and say, look at what happened with Girardi. We need to stop this whole business. They're all greedy lawyers. And, not to come full circle on how I started, but I will, which is I said at the very beginning, this is the worst thing that's happened to us in 30 years. The reputation that plaintiff lawyers have built up, the hardworking women and men out there doing this every single day, representing clients, many of whom are, not making a lot of money representing folks on a contingency basis, are going to suffer the consequences of this. So, fortunately, I'll just finish on this, Daniel. Fortunately, not so much a commercial, but it is COC and the plaintiffs bar and the organized plaintiffs bar have a good presence in Sacramento. And that's why they're taking this to the voters, or at least they want to. Because they know that in Sacramento, when it comes to tort reform, we've got legislators who listen to the fact that this is an access to justice. This is an opportunity for to protect the civil justice system. So let's all remember that. And if you're on the team that wants to protect the right to justice, you have to fight back when this kind of stuff happens. And if you're at a party and you start getting stories about Girardi, just like we all have gotten stories about the McDonald's coffee case, turn around and tell people look, one bad apple doesn't ruin the tens of thousands of men and women who do this for a living.
Yeah, with the McDonald's coffee case, for example, I just remember there was some documentary I watched on it, and as soon as it happened, all the financial news networks and this and that went out there, and tort reform was the hot word, and they were saying things like, "Oh, they sued McDonald's because the coffee was too hot," which we all know is not actually really the case. But that is what the plaintiff's bar is up against. Demetria, let me come back to you. I know we discussed this already, but let's get further into this. Let's get further into the divorce and whether the divorce is pretextual. And does the court care that the divorce is pretextual? And will the divorce courts the family law courts do any investigation to determine whether the divorce is pretextual?
Family court is largely based on the actions of the parties. So unlike the bankruptcy court, where there might be a little more investigation and understanding of where the parties are, the family court is not going to do that. They're going to wait for the proceedings of the parties. If someone files a motion that states something was illegally done or wrongful, then they will hear the motion, but the family court will not do its own investigation. But like the rest of us, I can almost guarantee that the judges watch the news, know what's going on. So we do have that, but in terms of their own investigation, no.
Got it. Okay. Let's just see what else is in the Q&A here. This one's interesting. It's actually a question directed to me. Dan, please tell us your impressions of Girardi and his capacity before seeking conservatorship. Like I mentioned, I actually interviewed Tom a couple months before all this happened. I never have actually publicly stated my opinion on his mental capacity. Part of the reason for that is it's weird when a guy is kind enough to allow you to have your first podcast episode with him, and it's kind of a big deal. And then subsequently you find out, ooh, maybe he wasn't the ethical person you thought he was. This is my take. Tom's very gracious. He's very charming. He uses lines like "forget about it, baby," and stuff like that. And he pulls it off. I was flattered by that charm during the interview. I did notice that he seemed a little diminutive. His clothing was too big for him. And when Mr. Girardi walked, you could see his age. You could see that physically walking wasn't the easiest thing that came to him. However, walking is one thing, mental capacity is another. And though I will say sometimes I felt like I asked him questions during the interview and I didn't necessarily get the answer I was looking for, and maybe he was off a beat, I never got the sense that he didn't know what was going on. I never got the sense that he was so far gone in terms of mental capacity that he couldn't make any decisions one way or another regarding his clients. I'm no mental health expert, but that was my personal lay opinion of what I saw. So that is that. We have, a bunch more stuff in the Q&A. What I want to do right now before we get to the very end of this is I want to address the MCLE stuff, and then I want to address some housekeeping stuff. And the housekeeping stuff is intertwined in what everyone's been talking about here, especially Brian with regards to the state bar and Erin, but we'll get to that. Let's talk about MCLE. Okay, so here's how it works, guys. If you want to get your certificate, which includes ethics, do me a favor, shoot us an email, info@westsidebarassociation.com. info@westsidebarassociation.com. Please provide us with your full name. Please provide us in that email with your state bar number. And please provide us in that email with the password. The password is "don't steal." So info@westsidebarassociation.com, shoot us an email. Hey, I attended the event, send me the certificate, your full name, your state bar number, and the password "don't steal." Don't steal. One more time, your name, state bar number, password is "don't steal." info@westsidebarassociation.com. Okay, before I hand this back to Eliza to close this out, let me just do one more housekeeping topic here. There has been a lot of talk about the state bar here. We've heard Brian's opinions of the state bar. We've heard Erin's opinions of the state bar. There's a lot to be said about all of that. And we have the sandbox proposals, the paraprofessional. We have the non-lawyers owning law firms and stuff like that. Guys, the state bar actually has open calls. And I'm very proud to say last Friday, there was an open call. At least half of the people who actually spoke on that open call were all members of the WBA. In the Westside Bar Association Facebook group, we have a very robust thread going on about the state bar's recent proposals. And because we do everything through social media, it makes it so easily accessible, and it enables conversations in such a dynamic and robust fashion. So if you haven't joined the Westside Bar Association Facebook group, it's free. There's no reason not to. And here's the better news. I'm on part of a listserv where we're discussing this stuff, and there are some attorneys who didn't just attend the open call. They listened to the entire thing. In other words, after I hung up, after I had my say, I hung up, these other attorneys hung on, and they've emailed me their impressions of what the state bar is saying. Guess what? The state bar is actually listening to the open calls. The state bar, people in the state bar have concerns about the ethics of allowing business people to practice law. What does that mean? Maybe it means that this grassroots movement where we get people chummed up in the Westside Bar Association, they go on there and have their opinion and they make their input on the open calls. Maybe there's a value to that. Maybe there's a worth to that. So much so that we're looking right now at the WBA to have a conversation with a lot of the leadership of the state bars. We're reaching out to CAOC, CALA, CELA, et cetera, to get state bar leadership together on a panel to have a conversation about what it is the state bar is doing. Obviously, Brian had a rather aggressive opinion of it in the sense that the state bar may not even be necessary at all. And look, that is a conversation that I think is part of this. Erin, you've certainly, having worked for the state bar, had a lot to say about it, and I appreciate that. And I think, interestingly enough, all this paraprofessional, non-lawyer ownership of the law firm stuff dovetails and ties in very aggressively to the Girardi situation. The Girardi situation is regularly brought up on those open calls. So to the WBA members who are getting involved, to the WBA members who are actually getting on the calls, thank you. You are making a difference. We're showing actually a very strong showing there, and there might even be another open call. We'll put updates in the WBA. Okay, guys. So Eliza, in just a moment, going to hang it over to you. Remember, you want your certificate, info@westsidebarassociation.com. Give us your name, state bar number, and the password is "don't steal." Eliza.
Thank you so much, Dan. And thank you to our panelists, Erin, Brian, Zev, and Demetria. This has been an amazing night. I loved hearing your opinions and your insights on the case. And just thank you for your time. And thank you so much to all of our attendees. We love you, and you guys make the Westside Bar Association what it is. Thank you for your enthusiasm, and hope to see you next time. If anyone has any closing statements.
Thank you, Eliza, and the Westside Bar Association, and Dan and fellow panelists. And everyone who attended and our sponsor. Thanks so much.
Yes, thank you so much. And I have joined the Westside Bar Association.
Yay.
Hey, and thank you for including me. I really appreciate it. And I will note that my opinions are solely my own and not representative of the Westside Bar Association or any other panelists here tonight.
And I would echo, thanks for allowing me to be part of this panel. And if you have questions, I did see some questions about the statute of limitations and other issues with respect to bar investigations. By the way, 5 years. 5 years with so many tolling provisions. They've actually gotten disciplined for the misconduct 11 years older, 11 years before. Okay, so yeah, it's a long, long statute. But if you have other questions like that, I'm always happy to answer questions. It's Erin at erinjoycelaw.com. I'm happy to answer any questions you might have arising from our presentation.
All right. Wonderful, guys. Thank you, everyone. Thank you. By the way, guys, wonderful panel put together by Eliza. Credit to her for putting this together. Credit to her for getting huge. We had nearly 200 people this deep into the pandemic on a Zoom. I think that says something. Guys, thank you all so, so much. We look forward to the next one.
Thank you.
Thank you, everyone.
Bye-bye.